I'm on page 948 of Contracts, Chapter 10, Third Parties, Rights and Responsibilities. Linkage, assigner, and assignee is the part within Section 3, Assignment of Rights. Linkage, assigner, and assignee. A firm that takes assignments repeatedly or continuously from a merchant whose dealings with customers are substandard may become entangled with defense of customers, notwithstanding waiver of defenses clauses. At some point, a question may arise about the firm's good faith. Aside from that, customers' defenses have succeeded simply because of the ongoing link between assigner and assignee. Notable authorities on the subject are Unico and Owen, and Leasing Service Court versus River City Construction Company. In each case, the claimant sought to override a buyer's defense by presenting itself as a holder in due course of a negotiable instrument. In Unico, the court wrote an elaborate opinion referring to Williams versus Walker Thomas Furniture above on page 497. Among other cases, many courts have solved the problem, the court said, by denying the holder of the paper the status of holder in due course where the financier maintains a close relationship with the dealer whose paper he buys. The court describes signs of close cooperation between dealers and assignees. The transaction is looked upon as a species of tripartite proceeding, and the tenor of the cases is that the financier should not be permitted to isolate itself behind the fiction fence of a negotiable instruments law and thereby achieve an unfair advantage over the buyer. And that's from Unico. In Leasing Service Court, the court said there are, of course, commercial cases in which a court has held that the seller and the alleged holder in due course were so closely linked that the entities were indistinguishable for purposes of holder in due course doctrine. In those cases, the manufacturer's representative either assisted or participated in the sale by the dealer, and the manufacturer's course of dealing was to furnish blank sales contracts to the dealer and to have the dealer assign the contract routinely as soon as the sale was made. Is a decision like that justifiable on the ground that a closely connected financier is in a position to monitor the merchant's selling practices and the quality of its products? The opinion that follows speaks to this point. Introduction to Chemical Bank versus Rindon Professional Association, which is our next case. The ruling here depended on the following sentence in a Massachusetts statute now superseded. Subject to any statute or decision which enables a different rule for buyers of consumer goods, an agreement by a buyer that he will not assert against an assignee any claim or defense which he may have against the seller is enforceable by an assignee who takes his assignment for value in good faith and without notice of a claim or defense, except as to defenses of a type which may be asserted against a holder in due course of a negotiable instrument under the Article of Negotiable Instruments, which is Article 3. The sentence was very like the first of three in a section of the Uniform Commercial Code, Section 9-206, that was the predecessor of current UCC 9-405. 403. The closing except phrase entrenched certain defenses which can be foreclosed under the section as revised. But that difference is not germane to the case. As presented here, the opinion does not include chapter or section references to the general laws and refers to former Code Section 9-206 as the Code section. So here we go, reading Chemical Bank and Rindon versus Rindon Professional Association. Supreme Court of New Hampshire heard this case in 1985. A firm named Intertel installed an office telephone system for a law firm, Rindon, under a lease purchase agreement made in April of 1974. The Contract required monthly payments into 1982, which at the time, Rinden might purchase the equipment for $1. Thereafter, Rinden received written notice that Chemical Bank expected to purchase from Intertel the payment rights. This document required Rinden's assent to its terms, and on June 11th, Rinden's office manager, John Satterfield, read and signed it. One of its terms included this provision. As leasee, you agree as follows. A, that your obligation to pay directly to the assignee, which is the bank, the amounts which come due as rentals as set forth in said lease shall be absolutely unconditional and shall be payable whether or not the lease is terminated in any way, and you promise to pay the same notwithstanding any defense, set off, or counterclaim whatsoever by breach or otherwise, which you may or might now or hereafter have as against you, lessor, which in parentheses the lessor is Intertel. After the bank received the signed document, it received also an assignment by Intertel of Intertel's payment rights for which it paid. About a week after Satterfield signed, Rinden received a letter from the bank saying that the assignment has been completed and that Rinden was obligated to make its monthly payments to the bank. After nearly 3 years of payments to the bank, the phone system began to malfunction seriously. Rinden replaced it and refused to make further payments to the bank. A three-party lawsuit ensued, which resulted in a master's report in 1984. In the meanwhile, Intertel had gone into bankruptcy. The report favored the bank. Rinden appealed, contesting a finding that the waiver clause was unenforceable. So those are all facts. Now we're going to what the judge said. This case is governed by the Uniform Commercial Code as enacted in Massachusetts. The version of the provision of Article 9 of the UCC applicable to this case is entitled, in quotations, agreement not to assert defenses against assignee, modification of sales warranties where security agreement exists, and quotations. Here the court said set out the statute with one qualification. It was identical to UCC 9-2061 as it stood prior to the revision of Article 9 effective 2001. The difference was that the statute omitted references found in the code section to lessors and lessees of goods as well as to sellers and buyers. The court concluded, however, that the statute applied because the Intertel-Rinden lease fit the UCC definition of security agreement. Yes, that's right. So this is analysis about the rule. The controlling law. Okay, the requirements of a valid waiver are that there was an agreement by a buyer who is not a consumer to waive defenses against an assignee and that the assignment was made for value in good faith. And without notice of a claim or defense, we find that these requirements were met so that the defendant validly waived his defenses against Chemical Bank. So that's your rule there. I think the master found that unless we find these requirements were met so the defendant validly waived. Yeah, I think this is the trial court's actual holding now that I think about it. The master found that Rinden agreed to the waiver of defenses clause and the evidence supports this view. The defendant does not claim that it is a consumer so as to make the statute inapplicable on that account. The defendant is a professional association, a law firm, not in need of special protections often provided for unwary consumers. So is is the rule applicable or not? Like, is that what's relevant right now? I'll have to keep reading. Next, we must determine whether there is a sufficient evidence to support the master's findings that Chemical Bank took the assignment for value in good faith and without notice of a claim or defense. As to the first issue, Chemical Bank paid Intertel over $8,800 for the assignment of Intertel's rights in the defendant's contract. As to the next requirement, the defendant asserts that Chemical Bank is not a good faith purchaser, mainly because the plaintiff and Intertel were too closely connected. Nothing in the record indicates, however, that the relationship between Intertel and Chemical Bank was anything other than arm's length commercial relationship. William Tupka, the Chemical Bank employee in charge of the Intertel account, testified that Chemical Bank's course of dealing and purchasing the rights to the Rindon contract from Intertel was typically of its transactions with hundreds of other clients with which it had entered into similar agreements. Chemical Bank and Intertel were not related corporations having common directors or owning shares of stock in each other, nor was Chemical Bank the only bank to lend to Intertel. So, were they or were they not closely related? Finally, the facts that Chemical Bank checked Rindon's credit rating and insisted upon an insertion of a waiver of defenses clause before it would purchase the assignment certainly do not prove lack of good faith as Rindon claims. Both Mr. Tupka and Kenneth Barron, former president of Intertel, testified that these actions were standard procedure for a bank extending credit. Moreover, even if there was any evidence of interrelatedness, Massachusetts law appears to look with disfavor on the admission of past dealings between parties to show bad faith absent some other indication of bad faith by the holder. See Bowling Green, Inc. versus State Street Bank and Trust Company. And that looks like a Massachusetts case. There is no basis to conclude that the master erred in finding that Chemical Bank took the assignment without notice of a claim or defense. Mr. Tupka testified that he came across nothing in his investigation of the Intertel account which would indicate that Rindon might have some kind of claim or defense relating to the lease agreement between it and Intertel. No evidence was introduced to contradict this testimony. The defendant next argues that even if the terms of this statute were complied with, the waiver of defenses is ineffective because it was given without consideration. The short answer to this is that none was required. According to Massachusetts, that an agreement modifying a contract within this article needs no consideration to be binding. The next argument focused on the defendant's contention that a provision in Article 2, such as that last cited, is inapplicable to transaction within Article 9 of the Code. The court concluded that Article 2 does apply to transactions in goods which involve both sales contract and a security agreement. The court rejected the argument ground in public policy. then we note that our decision, in accord with the policy of the UCC in general and of the code section in particular, to encourage the supplying of credit for the buying of goods by insulating the institutional lender from lawsuits over the quality of the goods. Massey Ferguson credit blank is where we got that knowledge from. A contrary holding would not have a chilling effect on loans made by financial institutions, but would mean that the law allows the plain meaning of covenants to be declared